Renewing your driving license or updating details is an important task and one which can now be done online relatively easily. Going to the DVLA's official website is a first stop for many drivers who want to change their address, update their vehicle logbook, V5C, or renew a license from the age of 70. But there are sites, which often look very similar to the official one, you should be aware of, as they ask motorists to pay them a fee for these services on top of any fee payable to the DVLA. Some of these services are usually free or much cheaper if you do it yourself through the official DVLA site. That's what happened to this person when they tried to update their documents. They said, "I recently applied for a renewal of my driving license through what I thought was the DVLA website, however it was not, and I have been charged extra for additional assistance. Can you help?" Advice Direct Scotland replied, "If you feel you were misled and given the wrong impression that the company's website belonged to the DVLA, this could constitute an unfair business practice. Some companies provide this service and will act as middlemen to apply for a license renewal on your behalf, but this should be made clear at the time before you get into a contract with them." The DVLA website allows customers to apply for a renewal directly to their website without the need to pay fees to a third party. In this case, you have entered into a service agreement, on top of applying for your license renewal. You should begin by sending a cancellation request to the company outlining why you feel you were misled and explaining that you would like to be refunded. This should be done formally in writing using signed for mail or using email with a read receipt. When entering into a contract with a trader to provide you with a service, your right to cancel the agreement will depend on where the order was placed and when. For orders that have been placed online, as is the case here, or by telephone or whilst you were in your own home, you may have rights under the Consumer Contracts, Information, Cancellation and Additional Charges, Regulations 2013. Depending on what you have contracted for, this legislation gives you a 14-day cooling-off period in which you can cancel the service without incurring a penalty, provided you have not waived this right by signing a form for a service to begin within the 14-day window. There are some exemptions to this regulation, and not all contracts can be cancelled dependent on their nature. Some examples of exempt contracts include a service costing £42 or under, the booking of transport or accommodation, the hire of premises for a specific date, emergency services or call-outs, or if the trader asked you to waive your right to cancel so that the service could begin within the cooling-off period. In most cases, the trader will have provided you with paperwork detailing your opportunity to cancel and the instructions to do so, and if you haven't received this by email or post, that could also constitute an unfair business practice. If you signed up for the service, then you may still have to pay for the period that you have had access to the additional assistance. This should only be a fraction of the total cost, so long as you are within the cooling-off period. For orders placed on the trader's premises, there is no automatic legal right to cancel unless the company has a policy that allows you to do so, and you may have to rely on the goodwill of the trader.